Policy 312201 and 412201, and just in case you don't know the policies, if it is a 3,000 policy, it's professional staff. If it's a 4,000 policy, it's service staff. So they basically, if there are any differences, I will notify you of that as well.
These are the ones we have to go with the teachers too.
Yes. And I can send you guys a list of those things in the notebook as well. There's a couple other things that we have to sign off sheets and some things that we have to post and train students, and we'll put all of this stuff together and put it in Kim's notebook for you to use later on. So 312201 and 412201 are the drug-free workplace, and drug-free workplace is just defined as a work site where the work is performed in connection with the employee's contract with the BOE. It includes facilities, property, buildings, offices, structures, automobiles, trucks, trailers, any other vehicles, and parking areas, whether we own it or whether we lease it by MCBOE. So if you are at Magic Years or if you are at Early Education Station, we lease classrooms there, so those are included in our drug-free workplace. Your workday includes any time when an employee is engaged in any work-related activity, which includes the performance of business during the regular workday, your lunch break, or any occasion having a connection with the BOE and or the employee's duties, and at all times the employee is on the job site. Covered employees are any person who operates a commercial motor vehicle. That is included but not limited to full-time regular employees, drivers, casual, intermittent, or occasional drivers, leased drivers, independent, owned, operated contractors who are either directly employed by or under lease to an employer who operates a commercial vehicle. The policy's primary goal is just to ensure that alcohol, intoxicants, look-alike drugs, and illegal drugs and or medically non-prescribed controlled substance use is eliminated, and that the BOE is safe and secure for employees, students, and citizens. Policy 3170 and 4170 is the substance abuse policy. We recognize that alcoholism and drug abuse may impair the performance of service personnel and professional personnel staff members. When appropriate and in the sole discretion of the board may assist the employees in a manner recommended by appropriate specialists in the treatment of those illnesses. However, in no case shall an employee's use and or abuse of alcohol and or drugs prevent disciplinary action from being taken against an employee for his or her actions by the board where the same arises out of, either directly or indirectly. Said employee's use and or abuse of alcohol and or drugs. Furthermore, this policy no way obligates the board to provide any particular health care or other treatment or to become responsible for payment if we require it. No staff member shall have his or her job security or promotion opportunities jeopardized by his or her voluntary request for counseling or referral assistance. (3122) 02 and 412202 is non-discrimination of genetic information. The board prohibits discrimination on the basis of genetic information. The board does not limit, segregate, or classify employees in any way that would deprive them of employment opportunities. Harassment based on genetic information is prohibited. The board will not request genetic information. 3123 and 4123, the ADA, prohibition against disability discrimination. The board prohibits discrimination against any employee based on his or her disability. The board will not discriminate against qualified individuals with disabilities in regard to job application, procedures, hiring, advancement, or discharge of employees, employee compensation, or job training. An employer is required to make a reasonable accommodation to a qualified applicant or employee if it does not impose undue hardship on the operation of the employer's business. There is going to probably be this year some requests for some accommodations based on COVID-19 and some different things. I know that AFT has hired an ADA lawyer and was working with them to come up with reasonable accommodations, because again, it does say that it can impose an undue hardship on the board. So what may be reasonable to one may not be reasonable to us in our job, of what we need to do to educate the students effectively. But we will work as much as we can and try to follow those requests. I believe AFT is even planning on sending out some type of a form letter to their members so that they can request accommodations and that sort of thing. So if you see them, let us know, and then we'll go from there. Because we do have to be ADA compliant, or we will receive huge fines. We do not have to provide, I think I read that. An employer is not required to lower the quality of our production standards to make an accommodation, nor is an employer obligated to provide personal use items. So if somebody thinks they need some kind of special chair or that kind of thing, we don't really have to provide that for them. Types of leave, by definition under school law, an employee's leave of absence is unpaid. If instead an employee is paid by the school board for an absence, then the employee is not technically on a leave of absence. The main federal law protecting civilian job rights and benefits for veterans and members of the reserve components who are absent from work serving our country is the Uniformed Services Employment and Reemployment Acts. FMLA, which is the Family Medical Leave Act, it provides 12 weeks of unpaid leave in any 12-month period. You do have to work a certain number of days in order to qualify for FMLA. And I believe it's like 155 or 160. However, proving it's 1,250 actual hours. Proving that sometimes is a little iffy, because if an employee's workday starts at 8 and they report at 7:45 and their workday ends at 4 and they leave at 4:15, they get an extra half hour in there every time. So it's not typically just your 8-hour day. So it's sometimes a little hard to prove. FMLA requires a serious health condition. It's defined as an illness, an injury, an impairment, physical or mental condition that involves either inpatient care or continuing treatment by a healthcare provider. The illness, injury, impairment, or physical condition must involve one of the following: a period of incapacity or treatment, absent at least 3 days, pregnancy or prenatal care, chronic serious health care. New mothers are entitled up to 365 days leave under the Parental Leave Act. So again, there are different things. Workers' comp is a little different as well. It might run along with FMLA, but workers' comp people seem to they get a little more leeway and a little more rights and regulations. So sometimes you may have somebody who's used their FMLA and that sort of thing, but if it's a workers' comp, then they're entitled to other things. So you can always just call and ask. And again, with HIPAA and that sort of things, we have to be careful, but we can, tell you if it's a workers' comp injury or whatever. This year there will be a new leave, and it is the CARES Act, and we will give you more information on the CARES Act when we get it. We've had many conflicting reports from Heather Hutchins, who is West Virginia Department of Education attorney, Rick Boothby a little bit yesterday, and he said he's not real familiar with it, so I believe that Mr. Cullen's going to contact Mr. Super at Bowles Rice and try to get something on that. But essentially what it says is an employee is entitled up to 80 hours of paid time off if they are asked to quarantine by a local health department, if they are seeking a COVID-19 test, if they need to be home because they think they have COVID-19. It's very general, and it doesn't require a lot of documentation. We're not allowed to ask for lots and lots of documentation from it, because the intent of the CARES Act was for employees who may not have days or employees who don't want to use their days to not come to work when they're sick. So it was meant to be very lenient in what we allow so that if somebody does have it, they don't come to school and spread it to everyone else. The CARES Act also provides some situations where an employee can get 2/3 of their daily rate. If their school or daycare is shut down and they have no child care. If, what was the other 2/3 one? There's another one.
They have conditions of the care of someone else.
Yes, if someone in your household that you directly care for has been diagnosed with COVID and you need to care for them, it could be a 2/3. There is also an extension of like an FMLA requirement. FMLA is basically unpaid leave unless you have days to take. With this CARES Act, you can get an additional 10 weeks of FMLA, which would be paid at 2/3 that rate. It says 12. The first 2 weeks you have to take unpaid, but then the other 10 you can get 2/3 of your pay if it's a COVID related, if you're on a ventilator and in the hospital and that sort of thing. And again, we'll try to get all of those things out to you.
This expires
This
December
is-
31st, right?
As of now, the CARES Leave Act expires December 31st. I mean, it may be something that they'll extend depending on, what's going on with the virus at that point. So, 3139 and 4139, staff discipline. The board retains the right and responsibility to approve or disapprove the superintendent's management of the workforce. When discipline becomes necessary, such action shall be in proportion to the employee's offense or misconduct, consistent with appropriate procedural and substantive due process, state law, board policy, and pursuant to the recommendation of the superintendent. 313901 and 413901, suspension. The superintendent, with approval of the board, shall have the authority to suspend school personnel with or without pay. The superintendent can only suspend temporarily pending a hearing. Such period cannot exceed 30 days unless ordered by the board. The board may suspend or dismiss employees at any time for immorality, incompetency, cruelty, insubordination, intemperance, willful neglect of duty, unsatisfactory performance, conviction of a felony, guilty plea of nolo contendere to a felony charge, and now for not mandatory reporting as well. The charges shall be stated in writing to the employee within 2 days of the presentation of the charges to the board. The employee will be given 5 days to request in writing a level 3 hearing, except that the dismissal for conviction of a felony or a guilty plea. An employee charged with the commission of a felony may be reassigned to duties which do not involve direct interaction with students pending the final disposition of the charges.
Does the DHHR add to that one? If they're child abuse, DHHR is another one that they can't agree with that, if I remember right.
Right. They cannot. If it is, and that's the things that Mr. Bauer will cover tomorrow under that mandatory reporting, and it is, but just as Mr. Collins said, if you are found guilty of child neglect or whatever, even if it's your own children, you will be dismissed and you cannot file a grievance over that. 3140, 4140, termination for cause and resignation. The employment of service personnel may be terminated at any time by the mutual consent of the board and the employee. Prior to termination, recommendation of the superintendent shall provide the employee with notice of the grounds for recommendation. The opportunity for the employee to respond will be in an informal hearing. The employee has the right to representation, as Mr. Boothby told us yesterday. Following the informal meeting, the superintendent has 2 days to put the charges in writing. Within 5 days of receipt, the employee can request a level 3 in writing to the grievance board, and unless it is a conviction of a felony. Again, they can be reassigned to duties which don't involve direct interaction with students. That can happen. And any employee terminated by the board shall be paid their full wages earned within 72 hours. Resignation may be withdrawn any time prior to board approval. Resignations may not be withdrawn after they have been approved by the board. Also, one of the things that on these policies, following those timelines of the informal meeting, the superintendent has 2 days to put it into writing, and you have 3 days and whatever, make sure that you're following those timelines, because if it does go to a grievance board and you're half an hour over that time, you'll lose. So make sure that you follow those timelines, and all those timelines are all listed in the policies for you. 3120, 4210 is the Employee Code of Conduct. The board recognizes the capabilities and conduct of all personnel greatly affect the quality of education provided to students in its schools. The board believes all employees are intrinsically motivated by the importance of the job that they do. The purpose of the Code of Conduct is to establish the appropriate standards of conduct for all personnel. This policy requires employees to respond immediately and consistently to incidents of bullying, harassment, intimidation, substance abuse, and/or violence, or any other code of conduct violation that impacts negatively on students in a manner that effectively addresses incidents, deters future incidents, and affirms respect for individuals. All Mason County employees shall exhibit professional behavior by showing positive examples of preparedness, communication, fairness, punctuality, attendance, language, and appearance. Contribute, cooperate, and participate in creating an environment in which all employees and students are accepted and are provided the opportunity to achieve at the highest levels in all areas of development. Maintain a safe and healthy environment, free from harassment, intimidation, bullying, substance abuse, and/or violence, and free from bias and discrimination. Create a culture of caring through understanding and support. Immediately intervene in any code of conduct violation that has a negative impact on students in a manner that preserves confidentiality and the dignity of each person. Demonstrate responsible citizenship by maintaining a high standard of conduct, self-control, and moral or ethical behavior. Comply with all federal, West Virginia, Mason County laws, policy, regulations, and procedures. 3211 and 4211 is the Whistleblower Protection Program. The BOE expects all employees to be honest and ethical in their conduct and comply with state, federal laws, and board policy. The board encourages staff to report possible violations of these expectations to their immediate supervisor. If the immediate supervisor is not responsive, or if the employee whose behavior is in question is the immediate supervisor, the employee may report to the superintendent. If the conduct relates to the superintendent, then it can be reported directly to the board president. Under this policy, the employer is prohibited from retaliating against any employee because the employee has disclosed any information to the employer or any other person or entity about an employer's alleged failure to comply with these provisions, or because the employee has cooperated in an enforcement activity. Employees are specifically prohibited from intimidating, threatening, restraining, coercing, blacklisting, discharging, or discriminating in any other manner against a worker who has exercised his or her rights under this act. Student supervision and welfare is 3213, 4213. Professional staff shall maintain a standard of care for supervision, control, and protection of students, commensurate with their certification, classification, assigned duties, and other responsibilities. And we're going to go into some other things, especially when we get to Title IX, about all employees, even though it says here with their certification and assigned duties, it even goes into substitute employees for Title IX. And are expected to establish and maintain professional staff-student boundaries that are consistent with their legal, professional, and ethical duties of care for students. The superintendent shall maintain and enforce the following standards. Professional staff member who transports students in a private vehicle shall do so in accordance with policy 8660. That's one of the ones that's going to be revised coming up soon. A professional staff member shall report to a building administrator any accident, safety hazard, or other potentially harmful condition or situation he or she detects in a reasonably prompt manner. I think that's one of the ones that sometimes, speaking just from my experience as an elementary teacher, if somebody had a little accident on the playground, it wasn't really that, maybe we didn't feel that big of a deal. We didn't always fill out that accident report. It is necessary because you never know what could come up later, and if we don't file that, then our insurance doesn't cover it. So it is important to stress that even if it's just a small thing, it probably needs to be put on that report. Professional staff members shall provide proper instruction in safety matters as presented in assigned course guides. Each professional staff member shall immediately report to the building administrator knowledge of threats or violence by students in a reasonably prompt manner. A professional staff member shall not send students on any personal errands for the benefit of the staff member or other school employees. A professional staff member shall not associate or fraternize with students at any time in any manner that may give the appearance of impropriety, including but not limited to the creation of, instigation, encouragement of, or participation in any situation or activity that could reasonably be considered abusive or sexually suggestive and involve harmful substances such as illegal drugs, alcohol, or tobacco. Any romantic, sexual, or other inappropriate conduct, including more communication of such nature with a student by any staff member, will subject the offender disciplinary action by the board up to and including termination of employment. And as you heard yesterday with Mr. Boothby, we think our people would not be crazy enough to do those sort of things, but it happens. I was at an investigation training with another county, and they had a teacher who was one of their best, and on the last day of school, they had a little party in the classroom, and one of the things she did was she sent the students to the kitchen to asked for a knife so that they could cut the limes for the alcohol that they brought and were consuming. And then after they consumed some of that alcohol, she let the students drive her car to buy more limes because they had run out. As they were interviewing the students, apparently it got rather obvious as they went on because they were slurring their words more and their heads were drooping and those sort of things. So, you know, that's a scenario that who would ever think, you know, is going to happen, but it did. It happened in a county in West Virginia. So this is why we train on these things. This is why we reinforce, you know, these things with them. A professional staff member shall not associate or fraternize with students at any time in any manner that may give the appearance of impropriety, including but not limited to the creation of, instigation, encouragement. Did I say that already? Sorry. If a student approaches a staff member to seek advice or to ask questions regarding a personal problem related to sexual behavior, substance abuse, mental or physical health, and or family relationships, the staff member may attempt to assist the student by facilitating contact with certified or licensed individuals in the county or the community who specialize in the assessment of diagnosis and treatment of the student's stated problem. However, under no circumstance should a staff member attempt, unless properly licensed and authorized to do so, to assess, diagnose, or treat the student's problem or behavior, nor should such staff member inappropriately disclose personal identifiable information concerning the student to third persons unless specifically authorized to do so by law. A report of the staff member's actions with regard to the student shall be made to the school principal or other appropriate supervisory personnel no later than the end of the following school day. A student shall not be required to perform work or services that may be detrimental to his or her health. Professional staff members are strongly discouraged from engaging as students on interactive media sites such as Facebook, Twitter, MySpace, YouTube, Skype, blogs, etc., except when such communication is directly related to curricular matters or co-curricular extracurricular events or activities with prior approval from the principal. Professional staff members are prohibited from electronically transmitting any personally identifiable image of students, including video, photographs, streaming video, etc., via email, text message, or through the use of social media and or online networking media such as Facebook, Twitter, YouTube, MySpace, Skype, blogs, etc., unless such transmission has been made in connection with pre-approved curricular matter or co-curricular extracurricular activities. A professional staff member who has reasonable cause to suspect that a student is neglected or abused or observes the student being suspected to conditions that are likely to result in abuse or neglect shall immediately, within 24 hours, report the suspecting of abuse. And again, Mr. Bauer will go into that more tomorrow. 3215 and 4215 is use of tobacco by school personnel. The Board of Education recognizes that the use of tobacco presents a health hazard which can have serious consequences for the user and the non-user. Tobacco product and tobacco-derived product means any product containing made or derived from tobacco or containing nicotine derived from tobacco that is intended for human consumption, whether smoked, breathed, chewed, absorbed, dissolved, inhaled, vaporized, snorted, sniffed, or ingested by any other means. It does include electronic cigarettes and vapor products. 4216, staff dress and grooming. While we do not have a dress code, the Board of Education believes that staff members, like professional staff members, set an example in dress and grooming for students to follow. Staff members who understand this precept and adhere to it enlarge the importance of his or her task and present an image of dignity and professionalism. The board retains the authority to specify the following dress and grooming guidelines for staff that will prevent such matters from having an adverse impact on the educational process. Be physically clean, neat, and well-groomed. Dressed in a manner consistent with their assigned responsibilities. Dressed in a manner that communicates to students a pride in personal appearance. Dressed in a manner that does not cause damage to county property. Be groomed in such a way that hairstyle or dress does not disrupt the educational process or cause a health or safety hazard. 3220 and 4220, staff evaluation. The Board of Education, through the powers derived from West Virginia Code, is responsible for the employment and discharge of all personnel. To carry out this responsibility, it delegates the superintendent the function of establishing and implementing a program of personnel assessment. It is the purpose of the program of assessment to strive for the improvement of the total county program, stress the importance of personal improvement on the part of individual service personnel, staff members, so that each student may be provided quality education and or service. Ensure the continuous improvement of administrative and supervisory services provided service personnel staff members. Establish a process of continuous and systematic service personnel staff member evaluation. This one, it may be important this year as well. 3251 and 4251. All staff will be assigned appropriate starting and dismissal times by the principal or chief administrator of the school. That, who knows what it's going to be at this point. Provided that the total regular workday will be no longer than 8 hours, including the 1/2 hour duty-free lunch, homeroom, class changes, planning periods, staff development. Teachers shall have the right to leave the building during their lunch period. A teacher may exchange his or her lunch recess for any compensation or benefit mutually agreed upon by the employee and the superintendent of schools. The teacher and the superintendent or his or her agent may not agree to terms different from those available to any other teacher within an individual school. The agreement shall be in writing. The classroom teacher shall be provided at least one period of unassigned duties during the student's day for preparation. The period shall coincide in length with the regular class period. And again, planning periods, duty-free lunch, all those things are maybe a little different this year. We do still have to provide the 30-minute duty-free lunch, and we will do that, but the times on when planning periods and things are may change a lot for staff this year. We'll still follow all laws that are in code about it, but they are giving us some flexibility to change some things. The grievance procedure, level 1 chief administrator is the county superintendent or his designee. Grievance request, conference and hearing of a hearing in writing, 15 working days of the grievance event, their knowledge of it, or the most recent occurrence. And they also are responsible for sending a copy of that to the grievance board. A notice of the conference or hearing at least 5 working days before the appointed date. That's our duty. The conference will be held within 10 working days of receipt of requests. Sometimes those timelines are waived depending on who the rep is and if they're available or not. Hearing is held within 15 working days of receipt of the request. The difference between a conference and a hearing is a conference is just a little more informal. Everybody comes in and kind of states what their grievance is. We listen, we see if there's anything we can do to kind of mediate that on our level first. Hearing is basically the same thing, but it's recorded. And on the grievance form, they put hearing first, so a lot of times people will check hearing instead of conference, and then they don't really want to have it recorded the first time. So it's, they kind of weigh that sometimes, but just so you know. A conference or hearing is conducted by the superintendent or designee. Leslie Tyree usually does our hearings and conferences. Findings of fact and conclusions of law may be submitted in evidence of decision. The written decision will be within 15 working days of that conference or hearing. If the employee is not satisfied with the outcome of the level 1, they can request a mediation at level 2 in writing within 10 working days after they receive that level 1 hearing. Choices of mediation by an administrative law judge, private mediation, private arbitration, can all be done. Administrative law judge is free. If they request private mediation or private arbitration, the employee must pay for those things. It's scheduled within 20 working days of request for the same. That really never happens. And nothing ever happens because that is because the grievance board is the one who schedules them, and they're not going to rule against themselves. So, report of mediation is documented in writing within 15 days. The arbiter shall submit a decision setting forth findings of fact and conclusions of law within 30 days. If they're not satisfied with the mediation, and I will tell you that it's not often that we get to a mediation and settle, but it does happen occasionally. The grievant has 10 working days after the receipt of that mediation report to file the level 3. The grievant files within 15 working days of discharge, suspension without pay, demotion, reclassification resulting in loss of compensation or benefits, or upon agreement of the parties. The formal hearing is on record. It is held within a reasonable time after the level 3 grievance is filed, and notice they put reasonable time on that one because it's long. ALJ issues a written decision within 30 working days after the hearing or after receipt of the proposed finding of the fact and conclusions of law. If someone files a grievance, they need to plan on approximately 1 school year, or about that time for everything from beginning to end if they go all the way even just to level 3. This year it has been even longer. Because the grievance board has been shut down. They're still not having hearings at this point. We have some right now set for September or October maybe, and we'll see what happens with those. But right now they're still not hearing any. If you don't like your level 3, you can go to the Kanawha County Circuit Court and file an appeal. You have 30 days to do that. And then if they turn you down and you're still not happy, you can go to the Supreme Court of Appeals. All grievance procedures and forms are on the grievance board website. And I just Google Public Employees Grievance Board, and you can just even put PEGB in there. It'll come up. It'll show it. It'll say forms. You click on that. All the directions are there. It's very easy to find. 3362, 4362, anti-harassment and violence. Racial, sexual, and religious ethnic harassment is a form of discrimination which violates Title VII of the Civil Rights Act of 1964 and the Title IX of the Education Amendments of 1972 Act and the West Virginia Human Rights. It is the policy of the Board of Education to maintain an education and work environment that is free from all forms of unlawful harassment and violence. As Mr. Boothby told you, and this is where we're going to get into a little bit more of this Title IX policy, is it has been redone. Neola's supposed to be sending it, board's supposed to approve it by August 14th. Neola hasn't sent it out to counties yet, so whether we can get it on there by that time or not is kind of up to them at this point. But simply because it's not been adopted doesn't mean we don't have to still follow the rules and regulations. I attended the Title IX training last week, and it scared the bejesus out of me. It's one of those things that you think, oh yeah, Title IX, da 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 da, and then they start into all these things, and And the first thing they said was, why does your superintendent hate you that they've given you this duty? Many reasons, but so this is going to be a little bit, again, it's a little bit long, but all of the people who have to be trained on this, the documentation that we have to keep on the training, the things that we have to place on the website, and that sort of thing is a little overwhelming. So Title IX is basically only 37 words, but it has long-lasting implications if it's not followed to the T. It says, no person shall, on the basis of sex, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. If you don't follow this policy to the letter, we can lose all of our federal funding. All federal money is tied to Title IX. So one visit by OCR could pull all federal funding for the county. One thing that they did say was that if you don't follow these regulations, we also cannot defend you in a court or against losing your certificate, because there's just nothing that can be done if you fail to be aware of these things and follow it. So that's kind of where I started to get a little worried about what was going on. Always err on the side of the child. And as Mr. Boothby said yesterday, there is an injunction to stop this from happening. So if it happens, we will let you know. Why amend the regulations is that the final regulations are going to impose legally binding rules on school districts rather than best practices, because that's what we've had before is best practices. Now it's going to be legally binding. We're going to adopt the United States Supreme Court's framework to address sexual harassment. We're going to provide clear guidance to school districts on how they must respond to the allegations of sexual harassment while at the same time meeting the requirements of constitutional due process. We're going to provide specific meaning and definition to commonly used terms. What are these regulations designed to do? They define conduct consulting sexual harassment for Title IX purposes. They specify conditions that activate a school district's obligation to respond to allegations of sexual harassment. They impose a general standard for the sufficiency of a response to those allegations by specifying requirements of a response. They specify when a grievance process to investigate and adjudicate allegations of sexual harassment, and they establish procedural due process requirements required in that grievance process to ensure a fair and reliable factual determination when a school district investigates and adjudicates a formal complaint of sexual harassment. And part of the new requirements are to protect the accused as well. In the Me Too movement and on all of those things, they have tried to put some things in place to protect the accused. Before it was all about the accuser, and they've tried to put some other things in place. What does Title IX do and do not do? Title IX is not a zero tolerance policy banning sexual harassment as such. Title IX does not offer effective protections to individuals against discriminatory practices within the parameters set forth under the Title IX statute and Supreme Court case law. Title IX does not preclude a school district from addressing the alleged misconduct under other provisions of the school district's policies and procedures. Terms defined by the regulations, and this is part of the changes in the terms that they've defined. A complainant means an individual who is alleged to be the victim of a sexual harassment, even if the complainant didn't make the complaint to you themselves. They are now the complainant. If a substitute cook sees an incident of a Title IX violation, she must report it to the principal. Then the person that she's talking about becomes the complainant, whether they filed the complaint or not. A respondent means any individual who is reported to be the perpetrator of sexual harassment. Importantly, a person may be a complainant or a respondent even where no formal complaint has been filed and no grievance process is pending. So if the substitute cook sees something, they have to report it. They've not necessarily made a formal report. A formal complaint is a document that initiates a school district's grievance process, and we'll talk more about what the grievance process is a little bit later because it's not the same thing as employee grievances. A formal complaint is not required in order for a school district to have actual knowledge of sexual harassment or allegations of sexual harassment. Activate a school district's obligation to respond promptly, including by offering supportive measures to a complainant. And that's one of the big things that we have to do. We have to offer supportive measures right from the beginning to the complainant. Sexual harassment is defined as quid pro quo harassment. That is conditioning any educational opportunity or benefit on the granting of sexual favors, constitutes a per se violation of Title IX regardless of its severity or pervasiveness. Quid pro quo harassment constitutes conduct without any constitutional protection. Any form of sexual assault, dating violence, domestic violence, or stalking as defined by the Clery Act constitutes sexual harassment. These forms of misconduct are so serious in and of themselves that no finding or pervasiveness is required. Unwelcome conduct of a sexual nature that is so serious, pervasive, and objectively offensive that it effectively denies a person equal access to an educational program as determined under a reasonable person standard. A school district has actual knowledge when any employee knows of sexual harassment. That's why it's important that they tell us. An employee knows of sexual harassment when they have observed it or have heard about it. Because if they don't tell you right then, and then something comes of it later and they have told somebody else, oh yeah, I heard they did this, then we're in trouble. And we're all in trouble, not just the person who didn't tell. Notice to a Title IX coordinator or to an official with authority to institute corrective measures is actual knowledge. When a school district with actual knowledge of sexual harassment in its educational program or activity refuses to respond to sexual harassment or to report the sexual harassment, such a refusal is clearly unreasonable under code and constitutes a violation of the final regulations. Supportive measures. Depending on who, one of the things that we learned the other day, and I haven't had a chance really to talk with Mr. Cullen since then, so he's kind of hearing some of these things now, is in our current policy, we have two Title IX coordinators, myself and Mr. Lehue. We have always been the Title IX coordinator, well, not since it was given to us. We were the Title IX coordinator, we were the investigator, and then we weren't really the hearing person. There was always some other form of hearing. Title IX coordinator, Title IX investigator, and Title IX hearing person have to be three separate people. So if I'm the coordinator, I cannot investigate any of them, or whatever that means. You can be informal investigators in your school so that you can bring the complaint to the Title IX coordinator, and then the Title IX coordinator can send the county investigator out to investigate further. The Title IX coordinator is the one who's responsible for seeing that all of this is carried out and that everyone is trained. So I'm thinking Mr. Leahy might be the perfect person because it's a big responsibility and it scares me. All right, so the Title IX coordinator is the person who presents these supportive measures to the complainant. So supportive measures are defined as non-disciplinary, non-punitive, individualized service offered as appropriate, as reasonably available, and without a fee or charge to the complainant or the respondent before or after the filing of a formal complaint, or where no formal complaint has been filed. We have to offer it no matter what. Such measures are designed to restore or preserve equal access to the school district's educational program or activity without unreasonably burdening the other party, including measures designed to protect the safety of all parties or the school district's educational environment or deter sexual harassment. We have to train, and I stop in between because if I don't say these things, I will forget them. We have to train every staff member. We have to train every substitute. We have to train every student. And we have to make it known to every parent. So we're gonna have to find a place on our website that we can do some sort of video training for parents as well. These are all things that we've never had to do before. Some examples of supportive measures can include counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leaves of absence, increased security and monitoring of certain areas of the campus, and other similar measures. The school district must maintain as confidential any supportive measures provided to the complainant or the respondent. The respondent has the right to all of these things as well. To the extent that maintaining such confidentiality would not impair the ability of the school district to provide the supportive measures. The Title IX coordinator is responsible for coordinating the effective implementation of the supportive measures. And I think back here we'll get into, it can't be punitive, and it kind of goes into what we can't do for that as well. Some responses to allegations of sexual harassment. A school district with actual knowledge of sexual harassment in an educational program or activity of the school district against a person in the United States must respond promptly in a manner that is not deliberately indifferent. A school district is deliberately indifferent only if its response to sexual harassment is clearly unreasonable in light of the unknown circumstances. A school district's response must treat complainants and respondents equitably by offering supportive measures as defined in code and by following a grievance process that complies with code before the imposition of any disciplinary sanctions or other actions that are not supportive measures as defined in code against a respondent. Emergency removal. Nothing precludes a school district from removing a respondent from the education program or activity on an emergency basis. And that's the key word there, emergency basis. Provided that the school district undertakes an individualized safety and risk analysis, determines that an immediate threat to the physical health or safety of any students or other individual arising from the allegations of sexual harassment justifies removal, and provides the respondent with notice and an opportunity to challenge the decision immediately following the removal. This provision may not be construed to modify any rights under the Individuals with Disabilities Act or the Rehabilitation Act or the Americans with Disabilities Acts. Administrative leave. Nothing precludes a school district from placing a non-student employee respondent on administrative leave during the pendency of a grievance process that complies with the code. This provision may not be construed to be modified under 504 rehabilitation, ADA, those sorts of things. The Department of Education will not deem a school district's determination regarding responsibility to be evidence of deliberate indifference by the school district or otherwise evidence of discrimination under Title IX by the school district solely because the department would have reached a different determination based on the independent weighing of the evidence. A school district's treatment of a complainant or a respondent in response to a formal complaint of sexual harassment may constitute discrimination on the basis of sex under Title IX code. For the purpose of addressing formal complaints of sexual harassment, a school district's grievance process must comply with the requirements of this section. Any provisions, rules, or practices other than those required by this section that a school district adopts as part of its grievance process for handling formal complaints of sexual harassment as defined in code must apply equally to both parties. A school district's grievance process is its Title IX policy and procedures. So once we have that new policy, we'll make sure that that's sent out so that you can see, because timelines and everything, again, will be set forth in that policy. So don't confuse the grievance process with filing something with the grievance board. It's just, I'm going to, talk about my grievance with whoever with you. It's not something as formal as that. In addition, any investigators must receive training on issues of relevance to create an investigative report that fairly summarizes the relevant evidence. We did that yesterday with Mr. Boothby. He did a little bit of training on investigation. We can always do more if they wish, and it could be one of these video type things that we can do, because they do give you lots of information and things to use at Bowles Rice. The Title IX coordinator, investigator, and decision maker are 3 different people. All 3 plus the person who facilitates the informal resolutions must be trained. Again, you guys are the ones that facilitate the informal resolution. Training must be posted, so we will have to put it on our website. These 3 people do not have to be employees of the school district. We can hire out. One of the things that they did suggest was that for either the hearing officer or the investigators, maybe working with Mountain State to see if they would be interested in hiring someone that we could use for these type of things, and have someone, because in larger counties it's a full-time job. And so have someone who just does this part of the investigation. Upon receipt of a formal complaint, a school district must provide the following written notice to the parties who are known. A notice of the school district's grievance process that complies with this section, including any formal resolution process, and that will be in our policy. Notice of the allegations of sexual harassment potentially constituting sexual harassment as defined in code, including sufficient details known at the time and with sufficient time to prepare a response before any initial review. Sufficient details include the identities of the parties involved in the incident, if known, the conduct allegedly constituting sexual harassment, and the date and location of the alleged incident, if known. The written notice must include a statement that the respondent is presumed not responsible for the alleged conduct, and that a determination regarding responsibility is made at the conclusion of this grievance process. The written notice must inform parties that they may have an advisor of their choice, who may be but is not required to be an attorney, and may inspect and review all evidence. The written notice must inform the parties of any provision in the school district's code of conduct that prohibits knowingly making false statements or knowingly submitting false information during this grievance process. If, in the course of an investigation, the school district decides to investigate allegations about the complainant or the respondent that are not included in the original notice, the school district must provide notice of these additional allegations to all the parties. The school district must investigate the allegations in a formal complaint. If the conduct alleged in the formal complaint would not constitute sexual harassment defined under code, even if proved did not occur in the school district's education program or activity, or did not occur against a person in the United States, then the school district must dismiss the formal complaint with regard that the conduct for the purposes of sexual harassment under Title IX. Such dismissal does not preclude action under another provision of the school district's code of conduct. So under that employee code of conduct, you know, you've got to employ them all. Title IX can include off-campus events. If we can consolidate complaints, if we have a lot of complaints on the same type of thing. An informal resolution, a school district may not require as a condition of enrollment or continuing enrollment or employment or continuing employment or enjoyment of any other right, waiver of the right to an investigation and adjudication of formal complaints of sexual harassment. A school district may not require the parties to participate in an informal resolution process and may not offer an informal resolution process unless a formal complaint is filed. However, at any time prior to reaching a determination regarding responsibility, the school district may facilitate an informal resolution process, such as mediation, that does not involve a full investigation and adjudication. In order to have an informal resolution, the school district must provide to the parties a written notice disclosing the allegations, the requirements of the formal resolution process, including the circumstances under which it precludes the parties from resuming a formal complaint arising from the same allegations, provided, however, that at any time prior to agreeing to a resolution, any party has the right to withdraw from the informal resolution process and resume the process with the formal complaint. Any consequences resulting from participating in the formal resolution process, including the records that will be maintained or could be shared. School districts are prohibited from offering or facilitating an informal resolution process to resolve allegations that an employee sexually harassed a student. So if it's an employee on student, it must be a formal complaint. When we are investigating complaints, the burden of proof is on the school system, not on the complainant. When we do investigate the formal complaint, written notice must be given within 10 days to both parties. All evidence that will be presented at the time of that hearing. And a determination on what 10 days constitutes will be made by the board when they vote on this policy. Is it going to be 10 working days? Is it 10 calendar days? How will that go? They'll decide that. After that, a written response will go to the decision maker. Then when there's a hearing, it's not the formal like an employee RIF transfer hearing. It's just that whoever your hearing person is hearing from you. And it's not necessarily a trial type things. We cannot do anything less than 10 days, but we can put in more than 10 days in our policy if we so choose. They have 10 days to preview the evidence, the respondent and the complainant, and then they have 10 days to review the report once everything is settled. Before any interview begins, both parties must be provided with written explanation of the allegations with sufficient details known at the time and with sufficient time to prepare a response before any initial interview. So this is something that different because we have to, before we can even interview the student, we have to put all of this in writing and present it to the complainant and the respondent both at that time. If additional allegations are found during the investigation or if the nature of the allegations changes, both parties are entitled to have that in writing as well. For interviews and evidence, both parties have a right to see all of the evidence collected, and interviews must be recorded. This is something else that's different. We must record all interviews. It can be audio or video, but they must all be recorded now. At the hearing, with or without a hearing, after the school district has sent the investigative report to the parties and before reaching a determination regarding responsibility, the decision maker must afford each party the opportunity to submit written relevant questions that they want asked or of any party or witness that may be called. They provide each party with the answers and allow for additional limited follow-up questions from each party. With or without a hearing, questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant unless such questions and evidence about the complainant's prior sexual behavior are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or if the questions and evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. The decision maker must explain to the party proposing the questions any decision to exclude a question that's not relevant. Following the hearing, a decision maker must provide a statement of and a rationale for the result as to each allegation. Not just one thing, every single allegation has to be responded to. The decision maker cannot be the same person as the Title IX coordinator or the investigator. The written statement makes a determination regarding responsibility. To reach this determination, the school must apply the chosen standard of evidence. Either party can appeal that decision on the basis of procedural irregularity, new evidence, or bias on the part of the investigators or decision makers. If there is a right to appeal, it must be offered to both parties. Written documentation must include identification of the allegations potentially constituting sexual harassment, A description of the procedural steps taken from the receipt of the formal complaint through the determination, including any notifications to the parties, interviews with the parties and witnesses, site visits, methods used to gather other evidence, and hearings held. Findings of fact supporting the determination. Conclusions regarding the application of the school district's code of conduct to the facts. A statement of and rationale for the result as to each allegation, including a determination regarding responsibility, any disciplinary sanctions the school district imposes on the respondent, and whether remedies designed to restore or preserve equal access to the school district's education program or activity will be provided by the school district to the complainant, and the school district's procedures and permissible basis for the complainant and respondent's appeal. The written determination must be provided to the parties simultaneously. So they need to be handed it at the same time. This starts the appeal process. The determination regarding responsibility becomes final either on the date that the school district provides the parties with the written determination or the result of the appeal. If an appeal is filed or if an appeal is not filed, the date on which an appeal would no longer be considered timely. The Title IX coordinator is responsible for effective implementation of any remedy. So if you guys come up with a remedy, Mr. Leahy will need to know so that he can effectively make sure that you're following those. The appeal. Both parties must be offered an appeal from a determination regarding responsibility and from a school district's dismissal of a formal complaint. Basis for appeal would be procedural irregularity, new evidence that wasn't reasonably available at the time, the Title IX coordinator, investigator, or decision maker had a conflict of interest or a bias against the complainants or respondents, and a school district may offer an appeal equally to both parties on additional biases. And that will be written into the policy as well. We could hire as well another person somehow. I mean, and when I say hire, I don't mean put an employee at the central office. I mean look through shared services with someone. An appeal agent that just looks into appeals. Once again, retaliation or reprisal is a violation of Title IX, and it goes into specifics about what that would constitute. And again, I'll put a copy of this PowerPoint presentation on in the notebook, and then we'll come up with something to post for everyone else. Record keeping. A school district must maintain for a period of 7 years records of each sexual harassment investigation, including all of the documentation, and it needs to be kept here at the central office, as well as you can keep it in your individual school, but we have to have a place to keep some here. An appeal. Any informal resolutions have to be kept for 7 years. All materials used to train our Title IX coordinators, investigations, decision makers, and any person who facilitates an informal resolution process. So I will be bringing tomorrow a sign-off sheet that you have been trained on Title IX. We'll put that with this presentation specifically, and that will be what we keep for 7 years, showing that that we have trained you. Let's see, record keeping again. I think that's good. There are descriptions for a Title IX coordinator and what they should look like. We're going to provide notice to everyone. Anyone can report. They can do it by mail, email, phone. We must train students, employees, and we must train parents on how to report sexual harassment. And I will try to go to the federal Title IX website where that they have a lot of these things, because What you should train your employees on to look for are student-on-student, gender-based, sexually offensive jokes, teasing, pranks, bullying, offensive touching or sexual groping, sexually explicit, vulgar, offensive gender-based language, patterns of any of the above conduct. Additional training considerations should be employee on student, crossing normal professional boundaries, close relationship with student, overly affectionate, student that may seek adult attention, unusual interest in the personal life of the teacher or student, employee acting more like a student than adults, communication or contact outside of school, using poor judgment in relation to a particular student, sexually related conduct, informs students, and again, it needs to be age-appropriate training for the students, but inform the students on who to report to and how to report. Inform students on Title IX policies and procedures. Inform students that they can report their matter to both law enforcement and the school district. There may be times when we are working hand in hand with the HHR and law enforcement on these things. Don't forget to make information available and provide training to individuals with disabilities and students who are English language learners. Your team may also include the outside agencies of law enforcement or DHHR. Create a positive school climate. Make clear to staff and students that discrimination of any kind, including sexual harassment, will not be tolerated. Inform students on the types of behavior that constitute sexual harassment and how to report it. Monitor that culture and climate. This includes the culture and climate of schools and other school activities, athletics, clubs, etc. Off-campus activities that come onto the school campus. If sexual harassment is reported, monitor for potential retaliation against the complainant or witnesses. We have to be careful of FERPA violations. Just like in the school system, CPS is required to conduct their investigations. We must let them do that. Working with them, they suggest maybe we come up with an MOU of understanding between CPS and Mason County Schools and law enforcement, in that, you know, just because you have stepped in, it doesn't mean we're not going to keep on with our investigation as well, because, you know, we are required to do so. And if that's not enough to scare you, we'll move on to the next one.
Can I ask a quick question?
You can. I don't know if I have any answers yet, but you can answer.
And I could be totally thinking about this wrong, but okay, so a boy starts calling a girl names that would, you know, probably be sexual harassment. I mean, that happens a lot. We know about. Normally, we would investigate, suspend, that kind of thing. Does any of those things now have to be given to the Title IX?
I think maybe they probably do need to be made available to the Title IX court, because and you can use your judgment on some of them. One of the examples that they gave the other day, and I'll send examples to you as well when we do this. Dr. Bond cut my time down, and so I'm sorry. But one of the examples they gave was that you have a substitute cook and she's in the hallway, and there's a boy and a girl at the locker, and the boy is attempting to kiss the girl. And when the substitute cook comes around the corner, they run in different directions. The substitute cook still needs to report that to the principal, because she doesn't know if they're in a relationship or not. She doesn't know if it was consensual, and, you know, they just got scared and ran different ways. So if she reports that to the principal, and the principal says, oh, they've dated for years, you know, and feels that there is nothing there, then it doesn't have to be brought further. However, if we're going to be putting out all of this documentation to parents and training students, it's better for us to just keep everything and say we knew, as you know, because again, ignorance isn't going to save us, as they've said. We could lose our license, the county can lose our federal funding.
It's like a lot of things we'll run into, like a boy and girl might date, and then they break up.
Right.
The boy's mad, he can start calling her names, that kind of thing.
And honestly, it's not a problem until the parent gets involved, so that's why we really, because in that, so it's probably, it's better just to, like they say, err on the side of the student, err on the side of caution,
So we go ahead and do our investigation and any discipline, and then also refer to the,
Yes,
I don't know.
yes. And we'll keep that for 7 years. Somewhere.
And now, if we bring a kid in because of that allegation, we don't have to do we have to do that whole, give them the written thing of what they're being accused of? Or
Not an informal.
Not in-
I don't believe. But I will clarify. I will go back and clarify it as well. I just had the training on Wednesday, so my head's still swimming as well. And that's why I will give you the whole PowerPoint that Bowles Rice sent, and it will outline all of that so that you can refer back to it as well, because anytime you ask me questions, that's what I'm going to be doing is referring back to it for quite a while.
I feel bad for that.
Anyway, that's why I'm thinking Mr. Lay, you'll be the perfect person.
Like how she passes the call.
I'm trying. It's probably not going to happen, but I'm trying hard. All right, anti-harassment and violence. We did that one. That's what we did there. Civility. This is a big one for some reason, and we're not nice to each other, and I don't always understand that. I can't see what these on are with them off, so. And I'm afraid this year it might be worse, this civility thing, because we've all just been, through things that we've never been through before, and everybody's a little on edge, and we don't know from one day to the next what we're going to be doing, or what we're expected to do, or how we're expected to do it, or how we're expected to fund it. And now we have Title IX on top of all of that, and so civility might be more of an issue this year. But we do have a civility policy for when employees are mean to each other, and even students. Because it's not just students, they're mean to each other. The following civility policy describes expected behavior of staff, students, parents, and other staff members. And sometimes I think they need to be reminded that we have a civility policy, and they are expected to follow this policy. School and school district personnel will treat students, other personnel, parents, and other members of the public with courtesy and respect. And again, I know that's not always easy, but you do it there, and then you let it go on your family when you get home. Students, parents, and other members of the public will treat teachers, school administrators, other school staff, and district employees with courtesy and respect. My youngest son said one time, when he got to middle school and all these kids found out who his mother was, and they were like, oh, she was my favorite teacher. And he said, I don't get it. Yeah, I just don't understand this. I don't know why they would think that. And then he said, the only thing I can figure out is that you're nice to them all day and you take it out on us all evening. And I'm like, yep, that pretty much sums it up. So, unacceptable disruptive behavior includes, but is not necessarily limited to, behavior which interferes with or threatens to interfere with school-sponsored activities, whether on or off school property, the operation of a classroom, an employee's office or office area, areas of school facility open to parents, guardians, and the general public, areas of a school facility which are not open to parents, guardians, and the general public. Cannot use loud and or offensive language, swearing, cursing, using profane language or display of a temper, threatening to do bodily or physically harm to a teacher, school administrator, school employee, student, or other member of the community, regardless of whether or not the behavior constitutes or may constitute a criminal violation, damaging or destroying school or school board property, any other behavior which disrupts the orderly operation of a school, school activity, a school classroom, or any other school board facility, abusive, threatening, or obscene email or voicemail messages. We get those sometimes here in the voicemail. Any student, parent, or member of the public who believes that he or she was subject to unacceptable disruptive behavior on the part of a staff member should bring that behavior to the attention of the staff member's immediate supervisor. And again, in policy, it goes into some other things of, I am not going into overtime. We'll take care of that here if it's needed. Rick did technology and acceptable use. That's it.